as lawyers, we act on instructions. And instructions have to be specific on what to deal with. And when you receive instructions, you've got to, first of all, have a discussion with your client and agree on what you are going to handle before court. Yesterday, we received a production warrant inviting us here, and we were never given the reason why this session had been organized by court. It's on record on Wednesday when we last appeared, court had adjourned the matter to 29 next week. Against our honest and humble plea that please, let's have a very short adjournment because there were pertinent issues concerning the liberty of our clients who wanted to raise. Those are issues which are canvassed under the Constitution. The issue of mandatory bail. And these are matters of law. We brought to the attention of court this fact that our clients had spent more than 180 days on remand. And the Constitution commands that once that happens, court has no choice but to release their chosen persons. And Section 76 of the Magistrates Courts Act, which reinforces the letter and the spirit of Article 23, is very, very categorical. It's clear that once the accused persons have spent 180 days on remand in matters which are exclusively triable by the High Court, no any other business should be handled by that court except entertaining the application for mandatory bail. And that is the matter we wanted to be addressed on Wednesday this week. Unfortunately, the substantive magistrate who is charged with the handling of this matter was not available. And then there was a stand-in magistrate. We requested him that please accommodate us this week so that we can make that application. First of all, we asked for Thursday. He refused. We pleaded and said probably Friday. He said please, the trial magistrate or the magistrate in conduct of this matter had given him strict instructions to adjourn it to early June, no any other date. It was by compromise that we agreed on 29th of this month. And they indicated that this week there is no date. Rather, there is no space. They indicated there was no space to accommodate us this week. That was the position of court. So in a surprise twist of events, last night, they issued the criminal summons or production warrant, rather. They issued production warrant, and shockingly, the state that moved the court to issue production warrant raised a communication which they never shared with us. That is weird. That is irregular. Because as a matter of law, they ought to have served us with a copy of the letter that moved the court to issue the production warrant for today. Even up to this particular moment we are speaking right now, we have not seen the contents of that letter. The state is holding it as if it's classified information. So when we raised these issues before the magistrate, we thought they would be serious, rather they would be accorded the seriousness they deserve. We thought the magistrate would grant us that opportunity. First of all, to make the application for mandatory bail. Then surprisingly, no, actually it's not an opportunity. Let me repeat this. We expected the magistrate to comply with the dictates of the law, that before you proceed with any other matter, first consider the application for mandatory bail. That is the law. It came as a shocker to us when the magistrate said, let the state first tell us why we are here. Meaning, even court, which issued the production warrant, wasn't aware why we are here. For us, we could not get to understand the reason why we are here from the state. It is the court to tell us. It is the court that issued the production warrant. So we felt we were insulted. With all due respect to the chief magistrate, you cannot tell the opposite counsel to tell us the reason why we are here when actually it is court that summoned us. It's court that issued the production warrant. So even the magistrate was oblivious of the reason as to why we are here. And on that ground, coupled with the fact that our senior colleague was not here, because Martha Karua is the lead counsel. And there is a reason why the chosen person took that decision to have Martha Karua as our lead counsel. And we wanted to work out a proper schedule. Because she jetted in on, early this week, and the whole of this week had been reserved for this case. And it's the reason we asked the court, we asked the court, please, can you fix this matter either Thursday or Friday? Can you accommodate us this week? For convenience purposes. But the court insisted that it should be next week. So she had to go back to Nairobi. Now, immediately after she has returned to Nairobi, you issue production warrant. Are you being fair? Are you being just? So this is the, rather, are you being fair or reasonable? So it's the reason we had to withdraw from the bar. And obviously you had the statement from our client. We have not had any opportunity to discuss these matters with them. And it would be very, very unprofessional on our part to proceed under those circumstances. One, where you have no instructions, you have not discussed the matter with the client. Two, you have no idea as to which matter is going to be handled before court, and therefore you are not prepared. Let me tell you, the worst thing a lawyer can do to yourself and your client is to appear before court when you are ill-prepared. So we came here prepared to handle the mandatory bail application, not anything else, because that's the command of the law. Now the magistrate was telling us to go into something else, which was not known to us. So we had to withdraw and wait for the date that was fixed for the mention of this matter. That is 29th of this month, Thursday next week. So that's when we shall be back here.
What is your take on
Explains the reason why we had to walk out, because he also appeared to be ill-prepared. He was not seized with the facts. I'm sure when we come back on the Thursday to raise that application, he would not raise that vexatious argument. I don't think he was very serious about it. It would appear he is not in any way informed that actually these people have been on remand since November last year. It would also appear that actually he has not taken time to educate himself about all the matters concerning this case, that it has got a long history from the General Court Martial, which also issued the remand warrants, up to the time when the Supreme Court quashed the proceedings. That is the 31st January. I'm sure he hadn't updated himself about those developments.
Maybe less say from me, how important is it in the law?
It's criminal conduct. If you attempted to proceed without instructions, it's not only a professional misconduct, but it is a matter that invites criminal sanctions against you. It's criminal. Do you know the gravity of this matter? The sentence is death. You purport to represent somebody without instructions, or when you are not at all prepared, and inadvertently cause a miscarriage of justice that can lead to execution of somebody, taking out somebody's life, and you take that matter lightly. Not any of us here. For us, we know the implications of the decisions being made here. We know why the state is making all these machinations and maneuvers. We know what they are up to. They want to execute Dr. Besigye. They want to kill him. They have said so. This is a perfunctory process. They are just taking him through a process leading to the gallows. We cannot, would be the last people to escort Dr. Besigye and Obedi Lutale to the gallows.